Hey, everybody. Welcome. It's True Crime Wednesday. Hope you're doing well. Um, I am still struggling with a little bit of froggy voice issue. I feel fine, but I am still recovering from some sort of crud. We tested for COVID and it wasn't COVID, but it's definitely been a hard one to get over. Like I say, I feel fine, but I still have a bit of a gravelly voice. So bear with me as we get ready to dive into True Crime Wednesday. There's a little bit to talk about in quite a few different cases. So we should probably get started. Um, First of all, for those of you who have been like me following the Vallow case for 4+ years, here we go again. The judge approved Lori Vallow's request to represent herself. Initially, for those of you who might need to catch up a little bit, Lori is being held in Arizona on charges, two different cases. The first case is the conspiracy to murder Charles Vallow, who was killed by Lori's brother, Alex Cox, who claimed it was an act of self-defense. Then the other charge was the conspiracy to murder Brandon Boudreaux. Alex Cox attempted to shoot Brandon Boudreaux and missed. So there are two separate cases that are going to be tried in Arizona. As Lori was being held and they were working on getting ready for trial, her initial attorneys filed a motion with the court expressing concern that Lori might not be competent to aid and assist in her own defense. And so the judge ordered two different evaluations. Lori was evaluated, and both evaluators agreed that Lori was competent. Her prior lawyers who had filed the motion for the competency evaluation withdrew because they believed that their communication with Lori had broken down, and she was appointed new lawyers. They then asked the court to withdraw the competency motion, and the judge declined because Lori had said that she wanted to represent herself. So then the judge, on his own motion, said, before I would allow her to represent herself, I need to be assured that she is, in fact, competent. So they waited for the results of the competency evaluations to come back. When they came back, both the state and the defense stipulated to the fact that the evaluations showed that Lori was competent. There was a hearing where the judge did have a conversation and inquiry with Lori. He asked her a lot of questions. One of the things he asked her, which I thought was interesting, was whether or not she was currently on any medication that would cloud her decision-making capacity, and she said there was not. Additionally, she said that she was on no prescription medication while she's been in the Arizona jail. So she is, according to her report, not taking any of the psychotropic or mental health drugs that were prescribed to her prior to her trial in 2023. So the judge found that she is competent and ruled that she will be allowed to represent herself. Trial dates have been set. The first trial, the judge did not make clear which case would be tried first. I'm kind of presuming that because Charles Vallow died, that his case would be tried first. But the first trial date is on the 24th of February. Then the second trial would begin on the 31st of March. So those two are coming up. That will be interesting to watch, particularly since she is now representing herself. She gave very cogent and thoughtful answers to the judge's questions. She indicated that she had already filed or had already drafted a response to the state's, to a discovery motion. To her attorneys had filed a discovery motion. The state had filed a response. She had already filed a response to the state's rebuttal to the state's response. And she seemed to be fairly conversant in the legal procedure and how to get things done. So there's no question that I think that is going to be worth the price of admission to watch Lori try her own case. But the judge has agreed that she is competent and has ordered that she be allowed to represent herself. So there are a couple of status and pretrial conferences coming up in advance of her trial. But really the next thing that will happen is her trial on February 24th. I know that lots of people have been talking about Luigi Mangione. This is the person who was arrested and has been charged in the death of Bryan Thompson, who was the CEO of United Healthcare. This is the incident that happened a week or so ago in New York City, where Bryan Thompson crossed from his hotel to the hotel across the street for an investor conference being put on by the parent company of United Insurance. And there was video of a man in a hooded jacket and with a COVID mask on, opening fire on him, firing at least 2 shots. The video shows him kind of fiddling with the gun. He fires a shot and apparently has some sort of a misfire, sort of messes with the gun, fires another shot. He then disappeared down an alley and was later discovered having gotten on an e-bike and disappeared into Central Park. The New York police started canvassing Central Park. They found a backpack that matched the backpack that he had been wearing at the time of the shooting. They were able to recover some clothing and a few other things from that backpack. And they were able to discover that he had checked into a local nearby youth hostel using a fake ID. And so they put out a nationwide dragnet trying to find the guy, and lo and behold, there have been some conflicting reports about how the report happened, but what we've heard is that there was a patron who was a regular at McDonald's for breakfast who pointed out to somebody behind the counter that they thought that the guy in the corner looked like the New York City shooter. And there were tips pouring in from everywhere into New York. And sure enough, the patron behind the counter in Altoona, Pennsylvania, called the police, and the police showed up and questioned this guy and were able to look through his possessions and he was taken into custody and was, in fact, Luigi Mangione. What they found on him was a manifesto that appears to be something of a confession as to why he did what he did. They identified him. They also found on his person a ghost gun, as well as the identification that he used, the fake identification that he used to check into the hostel in New York. It was the same ID and the same person's name. So he was arrested. He was arrested on unrelated charges in Pennsylvania, including weapons charges and possession of falsified identification, those sort of things. He was taken into custody and went to a bail and extradition hearing. He was denied bail, and the court in New York, when he was asked whether or not he intended to waive extradition, he said he does not intend to waive extradition. And the court in New York, he has been charged with murder in New York, and the governor of New York has already said she will issue a governor's warrant. So extradition is kind of a funny animal. I know we've talked about this before because we talked about it in relation to Lori Vallow's extradition from Hawaii, but that was a long time ago. So one of the things that comes up in extradition is that states are sovereign when it comes to enforcing the state's laws. So one state cannot go into another state and say, we want to arrest this guy on our charges. What has to happen because of the 14th Amendment and state sovereignty is that the governor of the charging state has to send a warrant to the governor of the holding state, the state where the defendant is, and request that the holding state release that person to have them extradited to the charging station. So in this case, the governor of New York has to issue a governor's warrant, which then goes to the governor of Pennsylvania. And that warrant then has to go through their process. One of the things that has to happen is there needs to be an identification. So it's a very old-fashioned and hyper-technical part of the law. So the next thing that has to happen is that they have to positively identify that the person that Pennsylvania is holding is actually the person who is wanted in New York. And so often there has to be an identity hearing where the district attorney in Pennsylvania has to put forward the information that, in fact, the person being requested is the person identified in New York and charged in New York. So a lot of times defendants circumvent that process by waiving extradition. Lori Vallow initially contested extradition for a day or two and then decided to waive it. And that often happens. So right now, we don't know whether Luigi Mangione will at some point waive extradition. But right now, he is saying he's going to contest extradition. He has a lawyer in Pennsylvania who's been retained for him, presumably by his family. And that person will continue to represent him as they go through that extradition process. He's kind of interesting, sort of a quirky guy from what we can tell. He's a fairly well-known and experienced criminal attorney, has done death penalty cases, and he is uh, continuing to represent Luigi until at least until he is extradited to New York. So there are some reasons why someone might want to contest extradition, even if they're convinced that their identity is going to be confirmed and they're going to be extradited. One of those things is to allow the defendant time to get counsel lined up in New York so that there's not a big gap in a big time gap when he's being held before he has an attorney who can argue for bail and can argue for all the other things and handle the arraignment on the indictments. So it does make some sense that he may wait until he has things in place in New York and then waive. The sheriff was asked whether or not he would be flown to New York, and he just scoffed and said, "Oh, heck no, we'll just drive him." That's certainly what happened with Lori Vallow when she was extradited between Idaho and Arizona, is they just loaded her in a car and drove her. And the same when they moved her from Madison County to Boise to Ada County. There was some information. There was some information released today saying that they were able to find fingerprints in New York that matched, that positively identified Luigi Mangione as the person who had been in New York. They also found a manifesto in his backpack when he was arrested. The manifesto essentially is a confession and says it had to be done, and that these parasites had it coming. Parasites meaning CEOs of major corporations, presumably. We also know that he cut off his contact with his family a few months before, to the extent that his parents reported him as a missing person. He was at some point, and most recently, living in Hawaii and working remotely. He has a bachelor's degree and a master's degree from the University of Pennsylvania, and which is considered to be an Ivy League school. He went to a very expensive all-boys private prep school for high school. He was the high school valedictorian. So he is smart, affluent, and it appears there is some evidence that was found on his Twitter account where he posted a photo, an X-ray of what he claimed was his lower back. He'd had surgical fusion on his lower back because of some sort of an injury, possibly a surfing injury in Hawaii. And he, excuse me, he roommates from Hawaii say that he was often in chronic pain. He often would, if he did something physical, he would often be in bed for a day or two afterwards and unable to move. And that he expressed frustration with insurance and medical communities. He also, in his manifesto at one point, quoted Ted Kaczynski, who was the Unabomber, who also, like Luigi, was from an affluent family, was highly educated, and ended up becoming an extremely mentally ill person who committed murders by placing bombs. He specifically said, I wouldn't want to use a bomb because that innocent people might be injured. He also said at one point that it would be ironic for him to kill Bryan Thompson on his way to a meeting with his bean counters. So it was definitely a recognition that he was there in New York City to for an investor conference for having to do with money. So we don't know when the next hearing will be. That is going to depend on how far along they get in this extradition process, and whether or not he waives extradition. So there have been a couple of developments in a couple of other cases, one being Donna Adelson. The judge, Donna Adelson, had lawyers. One of her lawyers, Dan Rashbaum, also represented her son, Charlie Adelson, in his trial. It came out later that Charlie Adelson had not waived his end of the conflict. Donna had said she was waiving any conflict Daniel Rashbaum might have. But it also required a waiver from Charlie, and it came out that there never was a waiver from Charlie. Charlie's appellate attorneys are using that as grounds for part of their appeal, and so Charlie Adelson would no longer agree to have Daniel Rashbaum represent him. Rashbaum initially said that his associate could represent Donna because they had built a Chinese wall and that the associate didn't have any involvement in Charlie's trial. The judge found that there was too much overlap and that no one from Rashbaum's firm could represent Donna. So she had to obtain new counsel. The new counsel includes a woman who was a judge. She was apparently removed from the bench, so there's a lot of questions about her competency. But the judge said there was a concern about whether or not she had a conflict, which the judge found that she did not have a conflict, even though she had been involved in Dan Markel's probate. So after Dan Markel died, his heirs, presumably Wendy, filed a probate case because he died without a will, apparently. Maybe he did have a will and it still had to be probated. I don't know all the details of the probate case, but the probate had to be done. And this particular judge who is now Donna's attorney, was involved in that probate case. The judge in Donna's case found that there was no conflict in the now attorney having administered, as a judge, having administered Dan's probate case. So they're now free to go forward and set a trial date. At this point, I don't believe a trial date's been set, but I will double check that. We also had a trial last week, the trial of Daniel Penny. Daniel Penny was a white former Marine who lives in New York, who was riding the subway when he was confronted by a Black man who was threatening people on the subway. And Daniel Penny perceived that there was a threat to him or to other people on the subway. And he had been trained as a Marine and knew how to administer a chokehold and did so. The victim, was someone who was under the influence of drugs. It was difficult for the coroner or the medical examiner to clearly say that the chokehold was the proximate cause of the victim's death. That it may have been exacerbated by the fact that he was under the influence of drugs, as well as what was considered to be sort of a sloppy and slow response by first responders. So he initially was charged with first-degree manslaughter. These charges all vary from state to state, so it's a little hard to draw direct parallels. But he initially was charged with murder, and the jury came back after 4 days and said they were deadlocked as to that primary charge. The jury instructions said that they couldn't go on and consider the lesser included until they made a determination on the main charge, and they said they were deadlocked. So the judge, after looking at the jury, the verdict form, said he did not believe that he could direct the jury to go on and consider the lesser included charges. The prosecutor then, not wanting to have to retry the case, said, well, we'll dismiss that primary charge, and then the jury can go on and determine the lesser included. And very surprisingly, the jury came back very quickly after the judge sent them home over the weekend to think about it. And on Monday, when they reconvened, they very promptly acquitted Daniel Penny. And which is sort of interesting because they were asked to go on and consider the other charges. It's sort of interesting that they would be deadlocked on the primary charge and then come back and acquit across the board. So there was a lot of speculation that maybe the jury, when the prosecutor agreed to dismiss the main charge, that may have caused some frustration with the jury or confusion from the jury, and so they moved forward and determined they were acquitting him. So that is not something that case is done, and he cannot be retried. There was, of course, a great deal of political spin on the case because he was white and the man was Black, and there was a great deal of many conflicting opinions within the community about whether it was right or wrong for him to have been acquitted. There also were a lot of questions about whether had there been a different makeup of the case, whether the DA would have brought the case at all. So, we try and not get into too much into the politics of things, but it did create quite a bit of controversy. I want to talk, there has been a trial going on that a lot of folks have been watching, and it is Joseph Ferlazzo, and I do want to talk about that case, but I'm going to leave it for a little later because I think people may have some questions about that. So I'm going to scoot on to just a few small updates on some other cases. In Karen Reed, the judge approved the delay to her new trial. It was scheduled to start in early in January, mid-January, and it has now been moved to April 1st. Now that had to do with several things. One of them being that both the defense and prosecution had asked. There was a new prosecutor brought in as a special prosecutor added to the prosecution team, and the prosecution decided that they wanted to do additional testing, that they wanted to do additional testing on the on her car and its info system. And the defense also wanted to do some additional testing. A lot of it had to do with the fact that the state, the Commonwealth, wanted to do this additional testing. And there had to be time for that testing to be done, for the reports to come back, and for the defense to have the ability to have their experts review it and perhaps call new experts as a result. So the judge did agree to set that out. The state also filed a motion opposing the use of the woman who testified, the emergency room doctor who testified about dog bites. And so the state had said that they filed a motion contesting her recognition as an expert. So there's going to be a Daubert hearing. That is a hearing to address the issue of the scientific basis of an expert's opinion. That is scheduled for tomorrow. So I'll be looking to tune in on that as well. Daubert hearings can be pretty technical sometimes, although this one doesn't appear that it's going to have a lot of maybe objective scientific data bringing it in. So that one will be waiting to see. Now, the other cases that are that we've been sort of talking about in Idaho, one is the Kohberger case. The change of venue was granted, a new judge was assigned in Ada County, and there was a hearing today behind closed doors on Kohberger's attorney's motions that were made ex parte. Now, we've talked before about ex parte motions. Ex parte motions are where only one side is there when the judge makes a decision. And ex parte motions are very unusual. It is not typical to have a judge hear motions that have that impact the case without both sides being there. In fact, it's for the most part considered to be unethical, which is why we had all of the fallout in the Young Thug YSL case, because the judge met with the prosecution and a prosecution witness ex parte. Now, there are some exceptions, and those often have to do with the defense attempting to get information that they don't want the other side to know because it would tip their defense theory. So it may have something to do with that. The other times that we have seen ex parte motions have been in around the issue of competency. There's no indication that they have concerns about Kohberger's competency. So I have to believe that it has to do with discovery that they do not want to tip the state's hand to. So I'm sure that that'll come out as time goes on, but right now we don't know what happened this afternoon in that case. The other case that we have been watching is Thomas Creech. Now, the reason we were watching it is because it deals with the death penalty in Idaho. We saw recently in the Kohberger case Ann Taylor making arguments about the use of the firing squad, which has recently been reinstituted in Idaho, and the difficulty of the state of getting the drugs that are usually used for lethal injection. So we heard Ann Taylor making a lot of those arguments. The judge took those motions under advisement. The state made the argument that those motions weren't ripe yet, meaning that they weren't at a stage in the case where the judge could make a decision about those motions. So, but Thomas Creech is a longtime occupant of death row in Idaho. He's been on death row for about 35 years. And he recently, the court found that he had exhausted all of his appeals, and they issued a death warrant for him. He was taken into the execution chamber, and the people who were tasked with starting IVs and finding a line to inject the chemicals, drugs, were unable to get a line. And after 8 attempts, they decided that they would stop. And so his execution was canceled after that. His attorneys filed an appeal on 2 grounds. One, saying that double jeopardy attached because he had received a death warrant and the state had been unable to carry it out. Second, they said that going forward with an execution after the aborted attempt was cruel and inhuman treatment under the 8th Amendment, because going into the chamber and having repeated attempts to start a line was traumatizing and cruel and unusual. The Idaho Supreme Court recently issued a decision and denied the appeal. So Thomas Creech can be rescheduled for execution. The reason I bring that up is because it does kind of mesh in with all the arguments that Ann Taylor made, having to do with Bryan Kohberger's case and the potential that he could be sentenced either to lethal injection or firing squad. So there's a little bit of news on the Murdaugh case. Russell Lafitte, who was Alec Murdaugh's co-defendant in all of the financial crimes, his federal conviction was overturned, and now the feds say they're going to retry him. He has also been charged in similar state crimes, and so Creighton Waters was in court today or yesterday discussing scheduling of when to start the trials in the state court having to do with Russell Lafitte. Alec Murdaugh is still appealing his murder conviction, and that will go on for quite some time before any of those will be decided. And finally, I wanted to talk a bit about the Ferlazzo case, which has been going on in Vermont. This is sort of a parallel case with Gabby Petito and Bryan Laundrie. So Emily Joseph Ferlazzo met Emily Ferlazzo. They were married. Um, in 2020, 2021, they were acquainted through a mutual friend. Joseph Ferlazzo was a tattoo artist, and they were acquainted through a mutual friend for whom Joseph had done tattooing and taught body piercing too. They started dating and then got married. They only dated a few months before they got married, and they decided that they wanted to get a small bus, like school districts use small, like they used to call them the short bus. And they bought a bus, and then they remodeled it. They were in communication with other people who were in part of the online community that were doing some similar things, and they were documenting their journey as they were remodeling, rehabbing this bus, and they were going to travel in this bus. Joseph was freelancing as a tattoo artist, and so he was sort of being featured as a guest artist, maybe at different shops, and so they were doing that. Um, they they had sort of an odd and conflicted relationship. They got married, and Joseph had always he testified during his testimony that he had always had polyamorous relationships, meaning that he had open relationships with more than one person, and she had said she wanted to be monogamous, and he had said they had agreed to that until the point where they both might want to open their relationship. It was clear that he was more interested in having relationships outside the marriage than she was, and it was a point of contention between them. So they got in their bus and they drove. They went to um, they went to Vermont. I think this is right. It's a little bit confusing, but they went there for Joseph Ferlazzo to have something of a family reunion with his sister. His sister had rented an Airbnb. Um, Conveniently or inconveniently, depending on how you look at it, it was the same complex where Joseph Ferlazzo's ex-wife lived. And the relationship between his ex-wife and he had been a point of contention between he and Emily, who is the victim in this case. There's no question that Ferlazzo, Joseph, drank a great deal, used a lot of marijuana, and so they went to connect up with his sister. They parked the bus in the parking lot of this condo where she was staying in an Airbnb, and at some point during that time, he shot Emily. He claims that she had become very physically abusive and that, well, he tells two very different stories, one to the police immediately afterwards and one on the stand today. So, for those of you who may not be watching it, the trial has been going on for 4 days. It wouldn't take you too much to catch up. And his testimony, the prosecution rested, and his testimony, he testified today. And it was on Core TV and Law and Crime, so you should be able to find it pretty easily. It's kind of a fascinating case. So, he was he left where the bus was parked, um, where he had seen his sister. He drove to a friend's house in the bus, and then he he had a motorcycle, and he took the motorcycle to someplace else. Anyway, he ended up going to see a friend of his and telling the friend, I need a ride to go pick up my bus, um, at in front of these other people's house. And the friend took him, and when they arrived, place was swarming with police cars. And he then admitted to the friend that he had killed Emily, that her body was in the bus, and the guy said, "Get out of my car." He got out of the car and left, was later found by the police and arrested. When he was taken into custody, the detectives who questioned him, he gave a very lengthy and very in depth interview after waiving his Miranda rights. And so he gave a very lengthy and very specific and in depth description of what had happened. Today, on the stand, he claimed that he had only just remembered that his wife Emily pulled a gun on him, and that he actually shot her in self-defense. There are a lot of really heinous details to this crime. The medical examiner testified earlier before uh, the close of the state's case that her body was dismembered, and that she had been stabbed multiple times post-mortem, which doesn't seem to me like an indication of somebody who shot somebody in self-defense. He hid it from the police and from everyone else for several days, and was going to dispose of her body in a wooded area. So he got on the stand, claimed that he only just recently regained the memory of her pulling a gun on him and him being forced to shoot her in self-defense. Um, I think that it would be really, if you're at all interested, listen to his testimony. Um, the state played the interview tapes of the police interview that he did right after he was arrested, and to compare, it's fascinating to compare the two. I cannot see a jury finding him remotely credible, and I cannot believe that he isn't going to be found guilty, or that a jury would find that he was justified in some way of killing her. The only indication is his testimony. There is no corroboration. There is no suggestion that she ever owned a gun or knew how to use guns. He contends that after they got together, he taught her how to use a gun and they went to the shooting range. But there's no evidence to support that other than his uncorroborated testimony. So if you remember in Roy Vallow's case, we had the police were able to go back and get logs of people who signed into a gun range, and there was other corroborating evidence that Alex Cox was out practicing shooting, um, other than simply the police saying somebody shot at Tammy Daybell and somebody shot at Brandon Boudreaux. So, unlike that, the only indication we have that Mr. Ferlazzo thought that his life was in danger is his own testimony today on the stand, and it is pretty clearly contradicted by his earlier statements to police. In his earlier statements, he does say that she was abusive, that he was tired of her being abusive, and was had enough. And he came back into their bus after walking the dog, got his gun out of the cupboard, um, crawled on top of her and shot her twice. Um, it's a little hard uh, to explain the multiple, like 8 to the front and 9 to the back, uh, post-mortem stab wounds. That sort of indicates a whole different level of anger uh, than than he suggests happened. And he spent a great deal of time saying, I don't remember. He claims that he doesn't remember giving a statement to the police shortly after he was arrested. He claims that he doesn't remember many of the things that happened around the time, that he doesn't remember what he did to her body. He doesn't remember. But he remembers being shown a, 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 a copy, or he remembers being shown his recorded statements to the police right after it happened. So really interesting, kind of fascinating, and does have some parallels to Bryan Laundrie and Gabby Petito. Certainly, Bryan Laundrie says that he killed Gabby to put her out of her misery because she was injured. There's certainly definitely different sort of levels of justification. So that one will be pretty fascinating for anybody who wants to tune in on that one. So that's about all I have for this evening in terms of updates and things that are going on, but I'm certain that you guys may have questions. So I see that Jen has been starting some questions, so let's have questions. Eat the food, Tina. Eat the food. Hi, good Lori. Do you think it will be difficult to find an unbiased jury in Luigi Mangione case due to all the crazy public support he's received for the killings? Thanks. Yeah, I do think that it's going to be very difficult. But, as we've seen in a lot of other cases, the more time goes by, the more people haven't heard or aren't following it or don't remember. So it's certain that his case is going to be sort of at the very top of things people may have heard about. I mean, it's really at the apex of news coverage. I mean, a wealthy CEO being gunned down in the street, and it having all of these odd hallmarks. There being a ghost gun. For those of you who aren't familiar with what a ghost gun is, what happens is a, a, a gun that you buy from a manufacturer, the body of the gun is it has the serial number on it. But with technology being what it is, and Mangione being a software engineer, one of the things that is now happening is that people are 3D printing the gun body, and then they're assembling the mechanism of the gun from gun parts, which is why it's called a ghost gun, because it isn't manufactured, doesn't have a serial number. The actual body of the gun is being produced by 3D printing. And a lot of folks have said they believe that's why there were problems with the gun, and he was forced to, to rack it and to manipulate it while he was doing the shooting. That's because it was a computer aided 3D printed gun body, and that the parts that would fit into it, those mechanisms are not always don't always work perfectly in that gun body. So I do believe that, not to go off on a tangent there like I already did, but I do believe that we're going to hear a lot more about this case. We're going to hear a lot more about all of those facts. But let's remember that very highly scrutinized cases have been able to find juries before. So, and Ted Kaczynski is a good example. I mean, enough time went by that people believed that he could get a fair trial. I am so sorry. I am still, after almost 3 weeks, struggling with getting over the last of the crud. So, in the short term, I think it would be difficult to find an unbiased jury for him, but I don't believe he's going to be tried anytime soon. New York does not have the death penalty, so it's very possible that he could plead. He did. It's clear that he intended for this to happen, that he was targeting people within the healthcare sector. He yelled an outburst at his extradition hearing about it being an outrage to the American people. So, I mean, I think it is possible. I think that the initial discussion is going to be whether he's competent and whether he's, and there's going to have to be a competency evaluation, because it's clear that he's had a major personality change in the very recent past. And so the first thing that will happen is they will have to ask about his competency. Then they will go forward. I would not expect that anytime soon that there's going to be any a trial anytime soon. It could be years before there's a trial. And let's remember that the Boston Marathon bombers, they actually found juries for them. So it's certainly, I think, possible to find a jury at some point. But the more time goes on, the more likely it is that people, the furor dies down and less people are exposed to it. So those are good questions. Hi, Polly Yo. Did you ever hear about the documents that Judge Boyce sealed? Not yet, but I'm still on it. I refiled a Freedom of Information Act request and was told that Judge Boyce has now indefinitely sealed them, and now his excuse is that they both have appeals pending. But I'm not giving up. Likewise, we are having a great deal of trouble getting any information out of Delphi. The Delphi case is one that really interests me and that I might be interested in writing about. But right now, Andrea Burkhart has filed a request to get the recordings from the trial and was denied. She then filed an action with the appellate court, and the appeals court upheld the Judge Gull's decision not to release the recordings of the trial. So that's frustrating. Right now, we're sort of, I say we because she's been trying to get them as well. I'm sort of meeting with a lot of resistance. This isn't surprising. I mean, we are seeing this more and more in more trials, and the more media there is, the more social media there is, the more likely it is that judges are going to, in my opinion, improperly uh, uh, deny public access. So I'm going to continue to be on it, both on the Vallow case and on Delphi, because I think we are just there's a problem there, and I do um, I do think that we as the public and as the media have a responsibility to push back against that, and against the lack of transparency in criminal trials. So, good question. I'm sorry I'm getting so raspy. Eat the food, Tina. Will you be attending the Lori Vallow case in Arizona? I don't think so. I may try and go for a couple of days, depending on when it is. I recently was invited to sit on a couple of panels at the Tucson Festival of Books. So I am going to be in Tucson in March. Depending on the timing of her trials, I might try and hop up to Phoenix and attend a day or so. So still waiting to see how that works out. I certainly will be following it, and as far as we know, it's going to be live streamed. So that makes there's a lot less pressure on getting into the courtroom when that's the case. So, but if it all works out, I'd like to get into the courtroom for a day or two. Will Melanie Gibb get immunity again in this trial in Arizona? Well, we have never known for sure that Melanie Gibb had immunity. We've all speculated about it. She certainly was friendly with the prosecution, exchanging more than 300 text messages with Rob Wood. However, they've never confirmed that she got immunity in Idaho. I don't know what the DA's office in Arizona might do, and how necessary her testimony will be. It would seem to me that her testimony is going to be very necessary. She was literally there the night before Charles was shot. So I would think that her testimony is going to be vital. And I don't know what the prosecution in Arizona is going to be willing to do to get her to testify. Like I say, we don't know for certain whether she was given immunity initially. It's always been speculation, but the prosecution has never confirmed it, and it didn't come out at trial. There were some, um, certainly Zulema, it came out that Zulema had immunity. So I guess we'll wait to see what happens in Arizona, but I'm certain they will want her to come and testify. Hi, Mary. Hey, I hope your move went well, by the way. I know you were moving. Do we have any updates on the Kentucky sheriff murder case? Well, we talked a little bit about this last week, and here's what we know. Sheriff Mickey Steins was charged with the shooting of Judge Mullins in his chambers, and the crime was caught on camera. His attorneys, Mickey Stein's attorneys, have suggested that there may be some sort of a heat of passion provocation defense. Once again, the definition of that varies from state to state. So Kentucky may have what most states would think of as a fairly old-fashioned and liberal interpretation of provocation in the heat of passion. What we do know is that Mullins and Sheriff Steins had been friends for a long time, but they actually went out to lunch together just before this happened, and that that the judge had been implicated in an unrelated situation. So there had been a deputy sheriff, so someone who worked for Sheriff Steins, who had been sued civilly initially for civil rights violations for trading sexual favors for women getting out of having to be in jail or allowed to be on an ankle monitor. What we know is that there were a great many female inmates who were part of drug court and were facing charges, were on release agreements that allowed them to be out on ankle monitors. Many of them, the inmates were required to pay for their own ankle monitoring, and in many cases, the women couldn't afford it. So they were stuck in jail because they couldn't afford their ankle monitors, or the state was threatening to put them back in jail because they weren't paying their monitoring fees. So this deputy who worked for Steins was trading favors for letting women off of their ankle monitors and not requiring that they post bail. And one of the women filed a civil suit, a civil rights action against the deputy, but also named Deputy Mickey Steins as a co-defendant because of his failure to supervise his deputies, because the sheriff is in charge of the jail. And so they allege that he had failed to supervise. The state also brought criminal charges against that same deputy, and he pled guilty. In the process of that civil case, they took a lot of depositions. One of the women who they deposed reported that the deputy was taping his meetings with women, and they were happening in Judge Mullen's chambers. And up until recently, there was no indication that Judge Mullins was involved. However, one of the women who was deposed in the civil case reported that she had seen recordings of the deputy having sex with women in Mullins' chambers. She knew Judge Mullins because she had appeared before him before on her charges, and she saw videotape of him having sex in his chambers with a girl. Now, we don't know whether a girl means someone young or whether it means one of the girls that she knew in prison. We don't know any of that. But that came out within the last week, that Judge Mullins was in some way implicated in that scheme that was going on. We don't know whether that was the thing that incited Judge Steins to do what he did, and we probably won't know until there's a trial. As far as I know, no trial date has been set yet for Judge Steins. But that law enforcement should have the recordings that were made by the deputy. So we still don't really have an answer as to why Deputy Mickey Steins walked into Judge Mullins' chambers and fired his gun at him. And Judge Mullins died of those gunshots. So it's not clear yet why, but there certainly appears to be way more to the story than originally we were led to believe. There, there, has been some suggestion that Mickey Steins believed that Judge Mullen was having contact with the sheriff's minor daughter, but there's never been anything to back that up. Nobody has at this point corroborated that. So we don't know if that has anything to do with it. But it was reported that Sheriff Steins attempted to call his daughter. When she didn't answer, he tried using Judge Mullen's phone to call her as well. There's conflicting reports of whether he typed her telephone number in or whether there was already a contact in the judge's phone for the daughter. So those are many things that I'm sure are going to come out as we get closer to trial. So good questions. I mean, every development seems to raise more questions about that case. So, we have two cases where we very clearly have a shooter on video gunning somebody down, and we're being asked to withhold judgment until we know all the facts. So, and I think that's going to happen more and more as technology means that we have surveillance cameras everywhere. I mean, there are surveillance cameras in New York everywhere. There were surveillance cameras all over the courthouse in Kentucky. So I think we're going to see more and more of these cases. Other questions tonight? Jen, I think you had a question about what's a Chinese wall. So no, oh, I saw it kind of zip through, so I thought I would talk about that. In attorney ethics and conflicts of interest, there is a concept called the Chinese wall. And what that means is, let's say you have a large law firm. Maybe you have a firm that in several different locations has 50 lawyers. Let's just say that you operate a law firm in Miami and they have satellite offices all over in Florida. Florida's big. Oh, there you go. And so what will happen in a large firm is they will make sure that the attorneys who are handling a particular case, for example, Adelson, that other attorneys in that firm don't have access to discovery materials, to correspondence, to emails, to that they are walled off, and essentially from all of the other people in their firm. It gets a little bit gray, more of a gray area when you have a smaller firm where it's a little bit more difficult to sort of partition people off from each other. A lot of public defender offices have people like I was that are sole practitioners who are all part of a group that have a contract with the state. So even though I shared office space with a couple of other sole practitioners who were in the group, we didn't share files. We didn't even share a computer server. The computer server in our space was actually partitioned so that there was no way I could have access to anything, anybody else's information through the computer servers. So it's important to kind of put those walls up and to make sure that you are partitioned off. But it really is a decision that a judge has to make after looking at all of the information, um, to be able to assess whether or not anybody else in the firm has had contact or had access to information that would sort of cause the conflict. So in Daniel Rashbaum's case, the judge found that there was an actual conflict and that it could not be waived because Charlie wouldn't waive it, and that it applied to Daniel Rashbaum's entire firm. So, I mean, ultimately, that's a call a judge makes. Most attorneys, if there's any question about whether or not there's a conflict, will say, I'm going to err on the side of caution and withdraw from the case. That was not the case with Rashbaum. And we see this happen, and I understand how it happens. It happens because you have formed a relationship with your client. You now have, it's a professional relationship, but you have to have a rapport with a client so that they trust you enough to trust your advice and to trust your judgment in the things that attorneys make the call on. And you have to have that relationship with your client. And I think that as time goes on and that relationship deepens, you can say things like Dan Rashbaum said. He was fond of Donna Adelson. He found her to have a lot of similarities to his own mother, and he found it. He had a personal fondness for her. Now, I can tell you over the years, I developed a personal fondness for quite a few of my clients. I mean, you do sort of get to know your clients, you get to know their quirks, and you get to know their case. So I can say that over the years, it's not that unusual for an attorney to develop a fondness for a client. Now, that doesn't mean that you overstep your professional boundaries with that client. I mean, Dan Rashbaum was not taking Donna Adelson out for dinner at night or going to her house, or I mean, he still had a professional relationship with her. He wasn't, being invited over for Mother's Day. But it can color your judgment sometimes, and I think to some extent that's what happened with Donna. Dan Rashbaum initially represented Donna, and then Donna said, I want you to represent Charlie. She waived any potential conflict for Charlie, for Rashbaum to represent Charlie. But now that he's represented Charlie, Charlie owns a piece of that conflict, the waiverability of that conflict too. So, and he was advised by his appellate counsel, do not waive because we feel like that is an appealable issue, that Rashbaum should never have been representing him because he already represented a co-defendant. And I think his attorneys are going to argue that it really wasn't a conflict that was was waivable. So that's what a Chinese wall is. It's certainly more effective in larger firms than it is in smaller firms. Rashbaum's firm is smaller, and I think the judge just felt like there were too many overlaps, and there wasn't anyone within Rashbaum's firm that could continue to represent Donna after Charlie's trial. So, good questions tonight. Anybody else? Any other questions before we wrap up? I do want to remind everybody that we're still collecting quilt squares for the origami style crane quilt for the woodcocks. and I'm going to be getting on that in earnest after the first of the year, once the holidays are through. And we also will have hopefully have some other quilting projects and some other fun that I think we're going to try and do after the first of the year. I also want to thank you all of those who were early readers for the book and posted your you'd think I hadn't been saying this forever, posted your reviews, because I noticed a couple of days ago that that the book is now coming up on recommended feeds. I was looking for a book by one of the people I'm on the panel with at the Tucson Festival of Books. I was looking for his book, and he writes true crime. And when I Googled it, lo and behold, Children of Darkness and Light came up as a recommended title. So thank you for all of you who posted your reviews and got us over that threshold so that the algorithm will begin to recommend it. Thanks to all of you who posted your Audible reviews and enjoyed the book on Audible. It is available on Kindle and Audible as well as in paper. So it's interesting. I've been getting a lot of feedback on social media, and it appears that it's doing moderately well. And I would very much like to get started on the next project. And right now, all of the problems with getting Delphi documents are standing in the way. So we'll see how that goes. So I want to thank everybody for that. I want to thank you all for joining us tonight and being with us. I know that there are lots of other ways you could spend your night. We have 100 people in our chat tonight. And I do want to let you know, if for some reason you don't feel comfortable posting your question in the chat, I am also happy to answer questions that are posted in the YouTube comments, as well as questions that are sent to me by email. So if you're a little shy, you can do it that way as well. And I do answer those. So thanks tonight for everybody who joined us. Thank you very much, Jen, who's always, as always, the moderator par excellence. And we will see you next week. And so join us again next week on Wednesday for True Crime Wednesday. And until then, good night. Have a great weekend. And I hope that your holiday plans are coming together. Good night.